This video is going to be about the legal effects there is when entering and terminating a marriage, and also about the different types of liabilities. First of all, we're going to start by describing the different types of liabilities, and starting off with personal liability. This describes how the debtor is liable with all assets they own. This also means that the debtor can risk to lose all of his or her private assets if they do not fill the economic requirements from the creditors. Also, if the debtor is personally liable for his or her company, the creditor can take assets from the debtor's private assets if the company does not fill any of the economic requirements from the creditors. Next up is limited liability, and this is when the debtor is liable for limited parts of his or her private assets. Then we have joint and several liability. This relates to when there is more than one person who is liable. Every debtor is liable for the debt as a whole, meaning the creditors can claim the full amount from the debtor they consider most economically solid or has the most valuable assets, for instance. Then we have pro rata liability, and in this case we also have several debtors, but here they are only liable for a percentage part of their debt. Then we have direct liability. This means that the creditor can claim a refund without checking whether the debtor is financially able to pay back their debt. The last one is indirect liability. Here the creditor must first apply in order to receive their money back from the debtor. If the debtor is personally liable for his or her company and incapable of paying back their debt, the creditors can claim refund from the debtor's private assets.
Then we would like to talk a little bit about marriage. And in Denmark, two people of the same sex or opposite sex are allowed to enter a marriage according to Section 1. Furthermore, it's only people above 18 who are allowed to enter a marriage according to Section 2. Then there is the law of spouses' economic relationships, which regulates spouses' assets. This includes decisions about maintenance obligations, right of disposal, liability, spouses' internal agreements, separate property, property sharing at the place of death or divorce. Then we would like to talk about property sharing between spouses. When two people get married, they enter a communion. The law of spouses' economic relationship is based upon the fact that the two parties are equal and there is a mutual obligation while the marriage still stands. Then there is property sharing between spouses. When two people get married, they enter a communion. The law of spouses' economic relationship is based on the fact that both parties are equal and there's a mutual maintenance obligation while the marriage stands. When two people enter a marriage, assets and liabilities are taken into the marriage, but each spouse still owns their own assets and are still liable for their own debt or liabilities. Separate control concerns the assets, while separate liability concerns the liabilities. Then there is separate control that I would like to go into. Separate control means that each spouse decides freely over his/her shares of community property assets. There are some exceptions to this law. The most important one is the one concerning the couple's permanent residence. According to Section 6, a spouse cannot legally, without consent from the other spouse, enter an agreement concerning transferring, pledging, rent, or leasing the family's permanent residency. Then there is separate liability, and the most important rule is that each spouse is liable for their own liability with their own assets, and the only exception to this is taxes. Yes. Then we have separate property. Separate property is a property arrangement that means that the assets that are separate property doesn't include the community property and is therefore not included in the share of community property. Separate property is not being, this also means that separate property is not being split at the termination of a marriage. Another thing is that separate property is agreed upon in a prenuptial agreement. This is according to section 19, 20 and 21. And these are the requirements that there is for a prenup. A prenup has to be written, it has to be signed by both parties. The prenup has to be tinglyst to make sure that, for example, creditors knows about this agreement. And then there's different kinds of separate properties. Separate properties of a divorce, complete separate property, combined separate property. If all of the asset that a spouse owns is separate property, it is known as a complete separate property. Then we have limited separate property and the sum division. Limited separate property means that the spouses can decide in advance that a specific amount of money has to be of separate control. What is earned from the funds or obtained through separate property will remain separate property.
Our last point is the termination of the marriage, which usually starts off with the separation, which is a way of testing whether a divorce is the right choice for the couple. At the separation, most of the legal effects of a marriage will terminate, and the couple must therefore share the community property equally. If the couple chooses to stay together, then they will have their legal effects back and live together as they did before. Divorce is the final termination of a marriage, thus the couple must share the community property equally. Furthermore, it's not possible for one of the spouses to prevent the divorce from happening. When looking at sharing the community property, we look at section 5, which states, in the event of separation or divorce, the spouses divide their assets equally unless they have entered into an agreement on the division under section 32 or otherwise follows from section 26. And then when looking at section 5, subsection 2, this states a spouse's assets, which in accordance with subsection 1, also called division wealth, the spouse's fortune is a property, community property between the spouses. As previously mentioned, when going through a divorce, the couple must share their community property equally between them. Therefore, when going through a divorce, the couple must make an evaluation of their share of community property. This is done by taking your total value of your assets and subtracted by your total value of liabilities. And if there is a surplus, then the surplus will be divided equally between the two spouses. And if there is a deficit, then this is cleared or reset due to the separate liability rule. And this is stated in section 29, subsection 1 and 2. When an asset is owned by both of the spouses, it is called a co-owned assets. This implies that when getting a divorce, the asset is included with half of its value to each spouse. Then we have chosen to mention a few exceptions to this rule, and the first one is stated in section 30, which is the protection of creditors, and this means that if one of the spouses owe the other spouse money, the spouse who owes money must be able to pay back the creditors first. And then we have the unequal division, which is stated in section 33, which states that if the largest part of the community property belongs to one of the spouses, then an equal division of the community property, which is stated in section 5, would be unreasonable. This enables the spouse to predetermine if that he or she could keep their part of the community property. This is mainly done when entering the marriage. Then we have the compensation for improper depreciation of community property, which is stated in section 40, which says if one of the spouses has abused his or her property or in an irresponsible way reduced their common property, the other spouse has the right to be compensated as if the reduction never happened. Then we have section 41, which is the compensation requirements, and the law of compensation if one of states that if one of the spouses has contributed to maintaining or increasing the spouse's property, which doesn't include the common property, they can be compensated.
Another exception is section 42, which is unequal division due to fairness. If a spouse has a fortune that is not part of the property division, the other spouse of the property division can be compensated to ensure that the spouse is not placed unfairly financially. In this assessment, emphasis is placed on duration of the marriage, any prior cohabitation, the spouse's income, wealth, and pension conditions, and circumstances in general. Another exception is section 4. In this case of property dividends, a spouse can be compensated to ensure that it's not unduly placed in pension terms. If the marriage, and then there are some conditions that are if the marriage has been of longer duration, there are large differences in the value of spouses' pension rights. Then there is subsection 2, which says that the decision shall take into account that the duration of the marriage, the assets of the spouses, and the circumstances in question.